All rise. The Court of Appeals, First Appellate District of Ohio, with the Honorable Jennifer Kingsley presiding, is now in session. Please be seated.
Good morning. Welcome to the First District Court of Appeals. We have 3 cases set to be argued this morning. When I call your case, please stand, state your name, the party you represent, and your readiness to proceed. The first case today is C-25-0082, Longenecker versus Veltrana, Inc. Is counsel ready?
Good morning, Your Honors. Ariel Fox on behalf of appellants Valantra, Robert Keene, and Joel Barron. Ready to proceed.
Thank you.
Good morning, Your Honor. Dave Everly from Mark Longenecker. I'm ready also.
Great, thank you so much. And then the second 2 cases have been consolidated for argument, C-24-0300 and C-24-0301, Haggard versus Durrani and Myers versus Durrani.
I'm Phil Williamson on behalf of Dr. Durrani and Cass. Please proceed.
Thank you.
Chapman on behalf of the 2 appellees, Haggard and Myers.
Thank you. All right, we will begin with the first argument, Longenecker versus Veltrana. Ms. Fox, you may come forward. Would you like to reserve time for rebuttal?
Yes, 5 minutes, please.
All right, and you may proceed when you're ready.
May it please the Court, Ariel Fox on behalf of appellants Valantra, Robert Keene, and Joel Barron. If Your Honors are amenable, I'd like to start by briefly addressing the jurisdictional questions, and then I'd like to move on to the merits. We view the Court's September 16th entry as raising 3 issues with respect to appealability. The first is whether the lack of an award of damages on the breach of contract claim renders the award non-final. The second is whether the breach of contract claim governs that finality analysis. And the third is whether the declaratory judgment claim and the breach of contract claim are the same and therefore the award is non-final. I'll try and address each. I don't want to belabor the points that were included in the brief that we submitted on Friday. As to the first issue, the lack of the award on the damages claim, on the breach of contract claim, the lack of damages award. Our view is that the trial court's order actually does resolve that claim in its entirety because the damages sought for the breach are Mr. Longenecker's ownership of the shares. And
Don't they also seek damages?
They do seek damages, Your Honor, but it's clear from what the complaint alleges that the damages that they seek are in fact the ownership. And I will concede that there is also probably a claim there, maybe not explicit, for costs and attorney's fees, but there is case law from the Ohio Supreme Court that says where 54B language is included in a final order, that the fact that the court did not rule on attorney's fees or costs doesn't render that claim non-final.
But as to damages, did the parties just agree what the damages would be?
The parties didn't agree what the damages will be in terms of explicitly briefing that or having some sort of stipulation. But as the contract is read, the damages here are the ownership of the shares. In fact, the contract claim speaks specifically to the ability to exercise the repurchase option. And just logically speaking, under the contract, no other damages could flow except for, and I'll concede this, maybe attorney's fees to prosecute the claim. But again, there's case law from the Ohio Supreme Court that says that alone does not render this claim non-final. And so I have never seen in the briefing, I've never heard my adversary say otherwise, that there are some other damages that flow from that claim. Now, there are 2 claims that are still below, and I can address how they are not inextricably intertwined, that may have separate damages there. That's a tortious interference claim, and there's also a claim for a breach of fiduciary duties. Those may have separate damages, but the breach here is the exercise of the repurchase option, and if we wrongly exercised it, then Mr. Longenecker is entitled to the ownership of the shares.
But then you would still have to go back for those 2 other claims?
That's correct. We would have to go back for those 2 other claims.
And isn't the final appealable order rule in order to avoid piecemeal litigation? Wouldn't it be better to have that all decided in one proceeding?
I take the point, Your Honor, that there is maybe a world in which it would be better, but here the parties agreed that the ruling on the breach of contract claim and the ruling on the declaratory damages claim essentially will guide. They're not exactly the same, but they will be potentially dispositive of those other two claims.
But
And
potentially dispositive means you still have to go back, and the whole point of the rule is to have everything decided in one proceeding. And can the parties' agreement trump the rule about final orders?
Well, I think the rule about, I take the point again, Your Honor, but the rule about final orders, first of all, there are provisions, and they've been promulgated by the Supreme Court, that allow you to sever claims in certain instances. There's 250502B that says there are certain rules when claims can be, rendered final. One of them, for example, a declaratory judgment claim is undeniably a special proceeding here. So we know that that claim can be up on appeal on its own. And then the question is, does the 54B language, was it properly ordered here such that it severs the other claims? And the way that we look at that is by rendering a decision on the two claims that are on appeal right now, declaratory judgment and breach of contract, are you otherwise going to rule in the first instance on the other two claims? And in this case, you're not. First of all, the two claims that were severed below have been alleged against different parties, and so they are inherently distinct. There are different factual findings that would need to apply to them. What is the fiduciary duty here? What is the breach? How did they tortiously interfere with the contract? And so I don't think we have the type of issue where the language says it's inextricably interlinked. Now, we will concede it will affect those claims, and that's why the parties decided together to jointly approach the court and say, this is going to be appealed regardless. These claims will be appealed regardless. And so we think it would, first of all, we think it's properly up on appeal, but also for the sake of judicial efficiency, if we get a ruling on these two claims, it may obviate the need to even try the other two claims. That's why the parties agreed. And so I will concede there is a world in which, yes, would it have been maybe best to have all of the claims decided? The appellee here moved on only two of them, right? And so we would have to go back on a trial on the two below. And I believe all agree, which is why we're here, that it would be much more efficient to address these two claims because we may not actually need to go to a trial on the two claims below.
So if we were to decide that the declaratory judgment claim, if that was a final appealable order, can the breach of contract claim just piggyback on that? Because there are differences.
You're absolutely right. There are differences. I do think the claims are not the same, which is speaking to one of the points that you raised. In terms of can it piggyback, let me answer a slightly different question here. I do believe the court undeniably has jurisdiction to decide the declaratory judgment claim.
Can we bifurcate the order?
I believe that you absolutely could, Your Honor, and you'll see there was a footnote in our supplemental briefing that says you can address this claim. It is certainly a special proceeding. It's been carved out under 2502B. You could decide that claim. Now, you could say you don't have jurisdiction on the other one and send that one back down. And I believe that you could decide the declaratory judgment claim today.
The declaratory judgment claim is not seeking a declaration that the contract was breached, correct?
That's correct. It is seeking a declaration on the ownership of the shares. Now, I think this is a very important point. The remedy sought under both of those claims is the same, and that's why I believe that the breach of contract claim has been effectively resolved in full, the court below, because the remedy is the same. It is declaring you are the owner of the shares. If you have breached the contract, you have improperly exercised the repurchase option, and so all of those shares are owned by Mr. Longenecker. But they are inherently different, but they're seeking the same remedy. And so to go back to your question, Judge Bach, I do think that they can piggyback off of each other in that sense, but I also think that the court would be well within its right to hold on to the declaratory judgment claim, sever the breach of contract claim, And then the parties would be forced to return to court and decide, what do we do with these remaining claims? And does the declaratory judgment claim, essentially, is it dispositive of all of the claims in the case?
I want to make sure that we get to the actual merits
Yes.
in your time left. Can you walk me through your perspective as to how this provision should be construed?
Sure. I think the provision has two conditions to it.
So when we're talking about the provision, just so we're clear, this is what the declaration is, right? The court is declaring the law about this provision. And it's section 1 of the agreement.
That's correct, Your Honor.
So did the court below actually declare the law?
I do believe the court below declared the law because the court made a ruling as to whether the repurchase option was properly exercised. And so the court read that provision and said you either fell into, I think improperly, you fell into the category where Volantra could exercise it or you could not. And so I do believe the court has fully declared Mr. Longnecker is the owner of those shares. I will concede I don't think it's crystal clear here, but I think reading the order, there is only one way in which you could say what happens from this order. Mr. Longnecker gets to own all of the shares. And you're right, that provision is section 1. We read it as having two conditions, only two, not a condition precedent. There are two conditions to exercise the repurchase option. One is your continuous service, and that is a defined term, is terminated. Continuous service means your service to Volantra as an employee, consultant, or director, that's explicit in the definition, is terminated. There is no question this happened in
And that happened, right?
This happened in July 2022 when he was removed as a director. Mr. Longnecker does not dispute that he was properly removed. The second,
Was he an employee and also?
the record is very clear that he was only a director. The parties have agreed that he was only a director. That is in the complaint. It was in, we briefed it, it was in our briefing. It was a response to, I believe, an RFA. He was only director. And you'll see in his briefing, he vehemently contests that he was ever an employee or a consultant. The second condition is that the holder does not continue providing services to Volantra in the role of an employee or consultant. And that latter portion of the clause, in the role of an employee or consultant, does not mean he had to have served that role beforehand, because we know there's a way he could have provided services to the company without being an employee and consultant, not only because it's captured in the definition of continuous services, but because it is exactly what he did. And it's not only what he did, it's the only role the two other founders who signed this same document
Counsel,
did.
what about the parenthetical that then says, and I'm paraphrasing, I'm not looking at the exact language, but then says like, that you could stick around as a director.
Yeah.
So when I walk through that, it says you can be terminated as a director, but so long as you're not an employee or consultant, you might still stick around as a director. And that seems very circular to me.
So I agree, and the exact language, Your Honor, is, and regardless of whether or not holder is then serving as a director of the company, right? That's the parenthetical that you're referring to.
Yes.
And I understand it makes it a bit convoluted, but as we indicated in our briefing, all that is saying is that there is indeed a way to continue providing services to Volantra in a different capacity. You can do that as a director. Now, it will not matter for purposes of exercising the repurchase option if you do so, but we gave two examples in which, in practice, you can see how that language would or would not work. They're in our briefing. I don't want to belabor them, but let me just give those.
Let me just interject a question before you go on. Is your argument that this is not ambiguous, that this clearly gives the company the repurchase option?
That's correct. I don't think that it is ambiguous at all, because I think there, as I said, there are, and I see my time is coming short, I see that there are instances in which you can see this playing out practically. And those two instances are lined out in our brief. We give an example of a director could serve for a couple of years, terminate their continuous service, and then immediately say, I'm going to consult for Volantra. Given that the former director is now providing services, they were providing services, they terminated them, but they're going to stay on as a consultant, their stock is not subject to the repurchase option, right? Conversely, you could have an employee who is a director and an employee, and they decide, yeah, I'm gonna give up my role as an employee, but I'm gonna stay on as a director. I have some institutional knowledge. My unvested stock would be subject to the repurchase option because I am going to continue providing services to the company, but it doesn't matter that I'm a director, right? And that's what the parenthetical does. Now, let me concede.
And counsel, you're out of time.
Okay.
Thank you.
Thank you.
Good morning again, everyone. May it please the court, I'm Dave Eberle for Mark Longenecker. As you saw in my short little filing on Friday, I take no opinion or stance on the jurisdictional issue. I understand the court's concerns. I expressed those concerns in the lower court. The trial judge added language to try to facilitate this appeal. I agree with the fact that it might make things more efficient, but I also agree that lawyers can't agree that something's appealable. That's up to the law and to the court. And so I have no opinion about that, but I'm happy to take specific questions about what happened if the court has any on that issue from me.
Well, as to the deck action, you prepared the complaint,
Right.
and my understanding is usually in a declaratory judgment, what is being sought is a declaration about what the law means. What provision did you ask the court to declare? And do you think the court actually declared anything in its opinion?
I can't tell. I can't tell whether the court, I had the same question from the judge's decision. I can't tell after that decision whether Mark owns these shares today or not, for purposes of an appeal or for execution, for that matter.
And doesn't that kind of go to the final appealable order issue?
That's my
Like,
concern.
if you cannot discern from the judgment where the court has said, I declare the law to be the following, then how do you even go forward with certainty on the contract claim, even if the contract claim went back?
I believe that the court would make the same determination because they are very intertwined. We asked the court to declare improper and to basically in equity say, here's what Mark should have. I agree it's a concern. I don't know. is the
What
answer.
declaration did you seek in your partial summary judgment motion?
I'm sorry, I missed the question.
What declaration did you seek in your partial summary judgment
I
motion?
believe it was to declare Mark an owner of 1 million shares.
And was that motion granted by the trial court's order?
I believe the fair reading of it is, although I concede it wasn't super explicit.
I mean, one of the purposes of a declaratory judgment is to provide clarity to the parties about some ambiguous provision in a contract, or typically it's an insurance contract, right?
Whether ambiguous or not, yes, I agree. I don't do a lot of insurance contract litigation, but here we asked the court to declare Mark an owner of 1 million shares, essentially.
But you didn't even need to include the declaratory judgment claim in your complaint. You could have just said, this is a breach of contract action.
Perhaps yes. But good lawyers don't issue a claim that is also viable, is my experience on that. So, yeah, perhaps it wasn't good lawyering on my part, or perhaps it was a redundancy, but I wanted to make sure my client's rights were protected, right?
So I just want to make sure I
Sure,
understand.
sure.
So in your partial summary judgment motion, you were asking the court not to construe any particular contract language, but to issue a declaration that Longenecker is the owner of the unvested shares?
I think that's hard to say, because it seems obvious to me that it was inevitable that the court had to construe that contract language in order to make that declaration, if that makes any sense.
It does.
Okay.
Turning to the contract language, can you address the circularity that I asked your opponent about?
Yes, there are two ways I look at this, and I think under both analysis, summary judgment is appropriate, and Mark should own 1 million shares. The first is a laser focus on that section 1A that the court was rightly focused on, the repurchase option. Is Mark subject to that? By looking at the language, the answer is no, he is not. A laser-focused look on that language and reading it out loud again, because it is a little confusing, and there's an argument that's ambiguous. I agree, I don't think it's ambiguous. If it is, this is Volantra's contract, which should be construed against them. But in the event the holder, Mark's, continuous service as defined by an equity plan, and that's a parenthetical that's sort of important, as defined by a different plan, a plan which Volanter concedes Mark was not subject to.
Well,
I
but
understand.
both parties signed this contract knowing that the definition of that term was coming from another document.
Completely true. The reason I mention that is because it bleeds into my second argument, which is not only does the language of this contract demonstrate that Mark should be the owner of 1 million shares, the context around the parallel signing of both of them also suggests that. And it has to do with the fact that Mark was never an employee. Because what this language says is the event that Mark's service ceases such that after such termination, he is, and this is the two words that are key that Ms. Fox did not mention to the court, such that he is no longer providing the services to the company as an employer consultant. And then we get to that parenthetical, regardless of whether he's a director, then he's subject to it, okay? So, 2 key points there. It's not disputed that he was never an employee or a consultant, okay? So, what they're really saying is what this repurchase option,
What about the point that if we read the contract to mean that it would essentially make the contract meaningless, given that the only signatories to this contract were directors?
that's the second part, which is the context for both of these contracts being signed. What we have here is a situation where Mark was a founder of this company. He never got his shares as an employee or a consultant.
Well, did
He never got
anyone else? I mean, my
Yes.
understanding of the factual record is that the signatories to this agreement were the founders.
They were, but the other signatories were also employees. That is the critical difference.
But they were all directors too.
They were all directors too. And so they all got these shares as founders. 2 years later, 1 year later, I don't remember the time frame, but later, when this agreement was signed, Volanter was converting to a corporation from a different law firm's recommendation. The recommendation to Mark was, oh, by the way, all of you founders need to be employees too now. I don't think anyone paid attention as to why, but that's probably the answer. What really happened here is we have a stock restriction agreement signed in parallel with an equity plan. I see these all the time. What's happened here is that these agreements are designed to incent employee attractiveness and intent and retention by allowing shares to vest over time, shares that someone gets as an employee. That's what these agreements are anticipating. They had the founders sign them too because they had the founders sign them too. But all of these documents are written to trigger events if someone's getting equity as an employee.
But wasn't
It's a square peg,
wasn't
round
the
hole.
reason they drafted it also that they had great problems when one of the founders departed?
That's a factual dispute.
So isn't that a reason to have, like, if this is ambiguous, isn't that a reason to have a trial to hear the purpose and the intent of the parties? And
I don't think so, because the ambiguity should be construed against the drafter.
In what way? How would we resolve that?
It's hard to resolve because I don't think it's ambiguous. I think that what they're trying to say is that you should rewrite this paragraph. It should say, according to them, in the event his continuous service is terminated, we can claw it back. But there's a second clause there. It can't be just any way that his services are terminated. They must be terminated such that he is no longer an employee. He was never an employee. It's impossible to have terminated his service such that he is no longer an employee. If they wrote the contract that said, in the event his services are terminated, then we can claw it back, period, they'd win.
So is
But they
it,
added that language.
I want to make sure I understand your position.
Yeah.
If we change the words no longer to not, would that change the meaning?
Yeah, no longer
you-
or never did and no longer are, right? And the reason they put that language in there is because this is all designed to deal with employment equity. that
So you're
things-
asking us to read into the words no longer that there was a previous employment relationship?
The only reasons those words would have been used is if there was a previous employment relationship.
Then how does that square with the inclusion of the word director in the continuous services definition?
If Mark had been an employee, I think just as Ms. Fox said, if Mark had been an employee and a director, and then was terminated as an employee, they could still claw it back.
Doesn't that then make the word director in the continuous services definition superfluous?
To Mark, but not to perhaps others. Yes. Just
But
like,
what would it matter then? What would it matter then if the only relationships that matter are employee
right.
or consultant? What would it matter then if we had the word director in the continuous services definition?
because if Mark had been made an employee as he thought he would be, and as Cooley instructed the founders should be made,
Well, I'm
And
not
the-
asking about this particular situation. I'm just looking at this text.
yes, so take Mark out of it. Anybody, if anybody had been made an employee and a director, that's not Mark, but if anybody had been, and they were fired as an employee but stayed on as a director, that parenthetical that you're focused on would allow them to be subject to the repurchase option. It would be. If Mark had been an employee, remained as a director, his being terminated as a director is irrelevant.
I'm really struggling to understand this language because as I look at it, I understand some readings of it. If
Right.
you're an employee, but you're terminated, but you stay on as a consultant, or if you're a consultant, but you're terminated, but then you become a director. But there is a reading of it that if you're a director and you're terminated, but you stay on as a director, and that seems nonsensical.
That is nonsensical.
And yes, so.
And it's nonsensical because the only way this applies is if you're an employee too.
And
That's
then
why that's
I
nonsensical.
understand your perspective, that you're saying that if you're a director and you were never an employee or consultant, then it doesn't even apply to you. So we're, I think, identifying some areas where this language would just simply not make sense.
It wouldn't make sense.
And that's ambiguity, right?
Except not in this context is my argument, because what's clear is that you have to be an employee to be subject to this, or a consultant. That's it. If, in the event, your service is terminated in any way, such that you're no longer an employee or consultant, no longer.
When we face ambiguity in a contract, what does the law tell us to do?
To construe it against the drafter.
And
if
is there
if
anything
possible.
else?
If it's ambiguous, you can look at outside facts from the contract, sure.
Are there any outside facts that you would have us look at to determine the meaning of this provision?
So there are other contractual issues, which is the equity plan. The fact that this agreement was signed in connection with an equity plan, a plan by which stock would be awarded an employee or a consultant, a plan which they now say Mark wasn't subject to because he was never an employee or consultant. This makes sense. It makes it less ambiguous because the goal here was to incentivize retention for employees, regardless of whether they're a director. That's why that parenthetical exists there. It shows you that this is a square peg round hole situation. Since he
Why
was never
would
an
you
employee.
have, can you help me understand why you would have a terminated director who would retain their unvested stock?
Well, first of all, I would say that Mark, as a completely vested owner before this was converted, shouldn't have his stock clawed away without consideration regardless, because he never got his stock through work. He got it through being on the ground floor, for better or worse.
So how is the stock valued? And didn't you ask for damages? Wouldn't there have to be a calculation?
The reason we asked for damages is the court suggested, I'm not in equity returning stock, but I see the loss, so I'm giving you money. That's sort of why we have two alternative claims of relief there, going back to a little bit of the jurisdictional issue.
Right, but on the contract claim, if he, to get the value out of that, he's got to get the value of the stock. I imagine there's some dispute about the value of the stock, right?
We frankly never got that far.
Well, so that's like a whole nother reason to go back and have a trial.
It could be. I'm not arguing for that. This isn't my appeal, frankly. Not to be flip about it. I understand and share your concerns. My client,
I mean, unless you all agree about the value of the shares, one way or the other, it's either X or Y, you'd still have, unless you agree, it seems unlikely that you would agree.
I think that when they tendered and tried to force the purchase back, they cut a check. I assume it was based on a formula on some of the other massive amounts of documents relating to this, but I frankly am not prepared to answer if that's true or not. I can't remember. My apologies on that, Your Honor. To me, this all focuses on this. They would like you to read this paragraph by saying, in the event his continuous service is terminated for any reason, it's repurchasable. But they've added language, Volantra did, that says, such that he's no longer an employee or consultant. And no longer is key there. You can't just strike those words. They remind the reader that this stock was anticipated to be given to him as part of employment. And we want you to stay as an employee, but we can repurchase it if you're no longer staying as an employee. That's the loyalty incentive that was designed for this. It's why the questions we all have about why would people sign these contracts exist. It makes sense when you remember that Mark was told by the outside lawyer, make everybody an employee. But they didn't make him an employee. He was the lone person to not be made as an employee. And perhaps that was to Volantra's disadvantage. But so often I'm asking the court to protect the little guy and to interpret contracts in a way that may be a little out of bounds. And I think often courts reluctantly say, I can't rewrite a contract. I feel bad for the guy, I can't rewrite a contract. This is the weird and rare opposite situation, where the drafter of the contract is saying, no, essentially rewrite this paragraph to screw over the little guy. I don't want to see that happen. So that's my argument here. Are there questions that do you have for me at this point in time? All right, thank you all. I appreciate your time.
Thank you.
I'd like to address briefly a few points that Mr. Eberly made. The first is, I just want to be clear about what is or is not in the record here. The fact that first of all, there were no other employees of Volantra at the time, and not only that, the equity incentive plan was never signed. It's not a signed document. I do believe the plan is in the record. It's not a document that each of these founders signed, for example. That wouldn't make sense. They weren't employees. Now, there may have been a promise for prospective future employment that was ultimately fulfilled for some of them, but at the time this contract was signed, no one was an employee of this company. Not the people who signed this agreement. There were no other employees. The equity plan was put in place in case there would be employees, and eventually there were, but there were not at the time. And I think that's important because Mr. Eberly's language was, let's be laser focused on the language in this provision. But if you step back and take a macro perspective, as Mr. Eberly is arguing and his client is arguing, this reading of the contract cannot be reconciled with the purpose of it. He says that the purpose of it was to retain talent. That may have been the purpose of the equity incentive plan, but the purpose of this agreement, as it is written, is to attract venture capital to Volantra, which at the time was a startup organization. And so
Where do we derive that purpose from? Is it internal to the document itself?
it is explicit in the contract, Your Honor.
Is that in the
and
background section?
That's right. In the background section, it says, and if you go to E, it speaks to the consideration point, which I'm not going to address for time's sake. There is consideration in this contract. It says the holder expects to personally benefit from entering into this agreement. For example, holder expects the existence and terms of this agreement to make the company a more attractive target for venture capital investment, which investment holder expects to increase the value of the stock. I want to note that while Mr. Longnecker claims that he was the owner of shares at the founding of the company, that's not true. He was the owner of units at the founding of the company. And it's distinct because when the company converted to an incorporation from an LLC, they did so because it was the purpose to attract venture capital. An LLC it's very hard in this space to attract venture capital. They became a Delaware corporation. And so the purpose of that was to attract venture capital funding. And the reason that they signed this stock restriction agreement, which under Mr. Longnecker's interpretation does not restrict his stock, the reason that they did so is because they wanted the ability to buy back stock if a founder left. And as you pointed out, a founder did leave, and that was the reason that they signed this agreement. I also want to just note, it is a contested fact as to what the outside law firm actually advised the company to do. So to the extent that we're looking at facts outside of the strict language of the contract because it may be ambiguous, I don't believe it is, That's a contested fact. And so if you are inclined to rely on that, I would encourage the court to send this back down so that we can indeed have a trial on these claims, because we contest that. It's in the paper. It is not in the record that everyone agrees that the law firm said make these guys employees, and it was to attract talent. And so I just want to be clear, that is not something that the parties have agreed on, and it's not something that is clearly in the record.
If we find this language to be ambiguous, what set of facts would you have us look at to construe its meaning?
I don't think the language is ambiguous, but in terms of construing its meaning, I would first look at what, first of all, their roles. This is in the record. What were their roles at the time that they signed the agreement, right? The record makes clear what events preceded their signing of the agreement. Who else was an employee in the company at the time the agreement was signed, such that it would make sense to have individuals sign this agreement at this time? I would look at what the state of the company was at the time they signed the agreement. A founder had just left under very messy circumstances. There was a very protracted and ugly discussion over ownership of stock, and immediately afterwards, they signed this agreement. And so I would ask you to look at what was the state of the company at that time, not what they believed it might be in the future, where they all might get future employment. Some of them did, some of them didn't. I would ask you to look at what is actually in the record. And if those facts don't resolve the ambiguity, I think the court is obligated to send it back down to have a trial on it.
Is there a jury demand from either side?
I don't believe that there, Mr. Everly can correct me, I don't believe there was a jury demand here. I do believe it would be a bench trial, which was part of the reason that we thought it might make sense to appeal it now. Can I say one thing with respect to jurisdiction? I'm looking at the complaint, and what the declaratory judgment claim asks for is not only Mark seeks declaratory judgment that he is the owner of 1,000,001 shares in the corporation's stock.
Did the order do that?
Well, the order didn't do that, but if I might, Your Honor, it also says, and that those shares are not subject to repurchase per the terms of Mark's stock agreement. And so I will concede it did not specifically and explicitly do the first, but it definitely did the second if you go to the order. What it says is, it is the court's opinion that plaintiff's ownership shares of defendant Volantra were vested when received at the company's founding, and then later it says Volantra's repurchase option did not apply to Longnecker. And then just briefly.
Because he received the shares as a founder of the company, and then it seems like all of that whole paragraph is as close to a declaration as we get from the trial court, but it doesn't seem like it's much of a declaration. It's more of a declaration that he is not in one of those categories, like an employee or a director or a consultant, despite the apparent factual agreement that he's a director.
So I agree, and I think you were focusing on the first error that we identified in our appeal, which is that you simply cannot reconcile the court's opinion with the record in this case, which we cite a case from the Supreme Court, we cite a case from the First District and sister circuits that say where you cannot reconcile this with the record, it cannot be upheld on appeal. And so I think alone, the fact that you have an error here is a reason that you need to overturn the ruling below. Thank you.
Thank you. Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision.
Thank you.
Next, we will hear Haggard and Myers versus Durrani, C-24-0300 and C-24-0301. Would you like to reserve time for rebuttal?
3 minutes, if I may, Your Honor.
All right.
Give my colleague a minute to get settled. May it please the court, Philip Williamson on behalf of appellants Dr. Durrani and Cast. I am happy to begin argument wherever the court would prefer, but I think the most straightforward path to reversing in this case is through the experts. So I'd like to talk briefly about Dr. Tayyeb's hearsay testimony, Dr. Bloomfield's reference to other malpractice actions in this case, and then the trial court's sort of inserting himself in the explanation of the spinal anatomy. Starting with Dr. Tayyeb, the legal question is easy. Dr. Tayyeb testified to hearsay, and in fact, if you read the transcript in this case, plaintiff's counsel basically reduced Dr. Tayyeb's deposition testimony only to the hearsay estimates, to the hearsay elements. This court has already held those to be inadmissible. So the question is, what kind of damage did that do? Well, here that evidence was clearly prejudicial because Dr. Tayyeb basically told the jury three things: that Dr. Durrani would routinely tell patients he could fix them, a line that...
Didn't the plaintiffs themselves testify that he told them that?
Yes, Your Honor. So you do have the plaintiffs testifying that they heard this from Dr. Durrani. It's a couple of important pieces. First, that he will fix you testimony is a through line from opening statement to closing. And what Dr. Tayyeb's testimony did, and again, plaintiff's counsel said this to the jury in closing. The purpose of Dr. Tayyeb's testimony was to give credence and credibility to these sort of offhand statements from the plaintiffs themselves about what they heard from Dr. Durrani. It was specifically, again, this is what plaintiff's counsel said during closing. This was to bolster the testimony of the plaintiffs.
And so is it your perspective that the harm comes because the testimony was a point of emphasis?
It is, though I have to add, the I will fix you testimony is not the only hearsay, and it's not the only source of prejudice in this case. Certainly on the he will fix them piece of things, the fact that it was made a point of emphasis, both in opening and in closing, is the prejudice as to the fix you testimony. But you also have Dr. Tayyeb telling the jury Dr. Durrani finds spinal stenosis as the justification for surgery in every case, which wasn't necessarily true here, at least as to Mr. Myers, and that Dr. Durrani is overly aggressive or takes an overly aggressive approach in his surgeries.
Didn't we already decide that, though? That particular piece, the other cast doctor saying that Dr. Durrani was overly aggressive, didn't we already decide that that was admissible in Bender?
Your Honor, your recollection of that may be better than mine.
Okay.
Even if so, we still have two pieces of clearly inadmissible hearsay that, again, when you go to closing argument, look at how plaintiff's counsel uses Dr. Tayyeb's testimony. He introduces it and says, and then you ice the cake, Dr. Tayyeb. Now, any parent of a child who's had a birthday party can tell you the icing absolutely makes a difference on a cake. That's perhaps the reason why Mr. Statman invoked the reference. He points to Dr. Tayyeb as describing what is consistent with what happened to these people. He leans heavily on the fix you testimony and the spinal stenosis testimony, ignoring the fact that for Mr. Myers, the primary sort of driver of his surgery was actually a different problem. You have plaintiff's counsel both in opening and closing emphasizing this idea of Dr. Durrani as a liar. You see it in the opening statements as to both of the plaintiffs. And then you have plaintiff's counsel relying on Dr. Tayyeb.
Do we have any indication that this argument was effective with the jury, though?
$5 million punitive damage verdicts on for fraud.
But
The jury's findings that Dr. Durrani exaggerated radiological findings, and he misrepresented to the plaintiffs their need for surgery and the outcomes for surgery.
But in other cases, we had indications that the jury specifically was motivated by Dr. Tayyeb's testimony. We don't have any of that here, do we?
So you don't have something as clean as Potts where, Dr. Tayyeb's testimony is sort of the only place you could have gotten, one particular key piece of the verdict. But what you do have here is testimony introduced specifically to be prejudicial to Dr. Durrani, specifically to build the case that he is a liar who lied to these two patients.
Well,
you see it show up in the verdict.
Didn't the experts and the plaintiffs themselves also testify that what Dr. Durrani represented to these patients was not true?
So you have obviously we're spending a lot of the time contesting the point of whether these surgeries were necessary or medically indicated, which actually is itself an important distinction. So you have this fight in opening statements about whether the standard is a surgery medically indicated or is the surgery necessary. Plaintiffs took the position that the standard is actually necessary. We explained in opening that actually the question is medically indicated because these were, at the end of the day, elective surgeries rather than emergencies. And so, again, what you have is testimony brought in specifically to prejudice Dr. Rani. And what I would say is, if you're looking for prejudice, if you're looking for the role Dr. Tayeb plays in this case, look at what plaintiffs themselves told the jury about it. If you're going to affirm, effectively what it means is that opposing counsel inserted testimony that was inadmissible, told the jury to rely on it, and in that way misled the jury, but we think the jury ignored him, which is going to end up being a theme when we get into some of the damages questions and the jury instruction. Dr. Tayeb is not the only problematic expert. You have this moment where Dr. Bloomfield refers to what Dr. Durrani typically does in other cases with his intake forms. And you have a colloquy, it's in the middle of the 700s in the trial transcript, where the trial judge himself, in response to defense's motion for mistrial, says, yeah, I made a note that when Dr. Bloomfield said usually, that probably indicates he's talking about something other than what's happening in these two cases. And again, you can connect that testimony to a through line from opening statement, where coming out of the gate, plaintiff's counsel is talking about the number of surgeries and the number of patients being seen by Dr. Durrani. And then the sort of coup de grace on the use of experts in this case is the restriction on demonstrations about the spinal anatomy. So there was at this trial basically a model of the spine. Plaintiff's counsel uses it in opening statements to describe how the spine works. Defense counsel doesn't, grab plaintiff's model, but does state, we're going to teach you about the medicine. That's a line from the defendant's opening statement.
Does the defense counsel cross-examine the plaintiff's expert on the spine?
That was going to be my next point, Your Honor, because the cross-examination itself gets short-circuited. So what you have is during Dr. Keith Wilkie's testimony, he stands up, takes the spinal model over to the jury and begins explaining, he tells them kind of the way that I would do this in med school, explaining the spinal anatomy. This is sort of towards the beginning of his direct testimony.
And whose expert is he?
Plaintiff's expert.
Okay.
You have a moment where the trial judge himself actually then asked Dr. Wilkie to explain the spine slippage condition that no one wants to try to pronounce to the jury. At that point, Dr. Wilkie, again, using his model, standing in front of the jury, explains it and then offers his patient-specific observations, specifically as to Mr. Myers. The trial court turns to defense counsel and says, is there anything that you want to demonstrate on the spine through Dr. Wilkie? This comes as a surprise to defense counsel, who did not expect in the middle of direct to be asked, hey, do you want to get up here and demonstrate something? And defense counsel says, I will defer to cross-examination. The trial court says, fine. Well, we get to cross-examination, and the trial court explains, I'm not going to have anyone else stand up and explain spinal anatomy to the jury. And in fact, I'm not even going to give you a chance to have Dr. Wilkie get up for cross-examination. Like, the one opportunity to have anyone explain spinal anatomy to the jury using this model was Dr. Wilkie.
Well, doesn't the trial court have authority to limit the presentation of cumulative evidence? I mean, wasn't that what the trial judge was trying to do, to avoid a number of experts using the stand, the bones and the model to demonstrate the exact same thing to the jury?
Your Honor, the trial court never quite gets around to saying that that's what he was doing, or that sort of avoiding the cumulative presentation of evidence was the goal. But even if the court's going to do that, it's the sort of thing you ought to tell the parties you are doing before you tell them, hey, your opportunity to demonstrate the spine to the jury is passed. Sorry, Your Honor?
If the trial court said, no, you're not allowed to do that, was there a proffer of what the defense expert was going to testify to? And any differences between what Dr. Wilkie said and what the defense would have said?
No, Your Honor, I don't think there was a proffer of like, here's what my expert's, explanation of the spinal anatomy would have looked like for the jury. You don't get that. But it's important to point out, Your Honor, we don't even get to cross-examine plaintiff's expert on this point because
Why not?
defense counsel said, I would like to defer this demonstration to cross-examination, the point where you would typically expect to get to ask questions of counsel. And the trial court says, fine. And then when cross-examination comes, the trial court says, actually, no, you're not going to get to go through this demonstration of the spinal anatomy. The result is you have plaintiff's counsel, plaintiff's experts being held up to the jury as the credible experts. The things you need to know, you can learn from counsel. And it's important here to remember, it's not just that plaintiff's counsel walks plaintiff's expert through the anatomy. It is that the trial judge himself says to plaintiff's expert, says to Dr. Wilkie, before you sit down, will you explain this for the jury?
And then, did the defense attempt in its direct any kind of demonstration of the spine?
No, Your Honor. There are 10 pages of the trial court saying, I'm not going to let you do this, I'm not going to let you do this, this is my ruling, we're done. And so defense counsel did not then sort of try to get up and defy him.
Which expert would have testified to that?
I believe it was Dr. Purcell was the neurosurgery expert. But I mean, either Dr. Purcell or Dr. Galustian could have given a similar demonstration on spinal column. It's also worth pointing out, during that 10-page colloquy, defense counsel also sort of asked the trial court, well, wait a minute, you're telling me I can't even do this on cross. So even aside from, what you would get out of the defense experts testifying, not even allowed to bring to the jury on cross-examination.
Even if we agree with you, how did this harm the trial or prejudice your client?
Absolutely, Your Honor. I think it's critical here. We're talking about the relative credibility of the experts, and you will see this throughout both the opening and closing arguments from plaintiff's counsel. And it's plaintiff's expert who is held up as the credible expert. It is plaintiff's expert that the trial court himself holds out to the jury as the person who can tell you everything you need to know. You get the trial court's imprimatur even on the explanation of why Mr. Myers didn't have spine slippage. Again, I would encourage you to read the transcript on this portion of Dr. Wilkie's testimony, where the trial court says, before you sit down, can you explain spine slippage? You immediately get out of Dr. Wilkie, not only okay, here's what this medical term means, and here are all the ways Mr. Myers didn't have it. That is you get the trial court's imprimatur, because this answer is coming not out of plaintiff's counsel, not out of plaintiff's counsel's question, but the trial court himself.
The error
asking the
that
question.
you've assigned is not that the trial court aligned itself with the plaintiff's experts. The error that you've assigned is that the trial court did not permit a demonstration by the defense experts. Which thing are you complaining about?
So the error that we assign is that they did not permit the demonstration by defense experts. The reason why that is a problem is that you now have uneven, and we point this out in the brief, you have uneven demonstrations of credibility between the plaintiff's experts and the defense experts to the jury. A problem made worse by some of the trial court's additional behavior, but that is the core problem, that you have plaintiff's experts getting to explain the spine and tell the jury, here's everything you need to know, and defense experts are denied the opportunity to do the same.
All right, and counsel, you're out of time. Thank you.
Thank you, Your Honor.
Good morning.
Good morning.
Alan Stabman on behalf of the appellees in this case. I want to go back to this spine demonstration. The spine demonstration, and the reason the judge limits it is it is a straightforward anatomy discussion. This is a vertebrae, this is a disc, this is a nerve root. I do it in opening because they have to understand some basics to be able to look at the medical records that are part of my opening. Defense attorney gets up and repeats exactly what I say with their own spine model. So then, when our expert testifies, which we need to get into the record, because my opening's not evidence, nor is defense counsel, Dr. Wilkie gets up and he goes through the parts and pieces. He doesn't relate it to the plaintiffs at that point. It's just straightforward. This is a disc. This one is a disc that's come out of its disc space, pulls the bones. This is what spondylolisthesis looks like. And at no time did they object to say he's not representing the anatomy correctly, Judge.
Well, how do you respond to the argument that allowing plaintiff's experts to testify about the anatomy, but not allowing the defense experts to do the same, frames the defense experts as the experts, the credible ones? How do you respond to that?
Well, I can do it by what they didn't tell you today, which is the judge does the same thing on credentialing. We're not going to listen to 4 experts explain how a doctor becomes board certified. And since my expert goes first, this is how you get board certified, 1, 2, 3, 4.
So is this really a limitation on the cumulative presentation of evidence?
That's what the judge says in his ruling. I'm not going to have the jury hear the same thing twice. And when they do attempt to go over it twice, which they often do, and I don't remember specifically in this transcript, he says to the defendants, we have already heard the basic anatomy. Let's get to the point now.
So in this case, you don't remember if that happened, but you assume that if it did happen, the judge would have said, okay, we've already heard this, move along.
Well, he goes a little further than that, because he'll say, they've already heard how someone is board certified. Let's not do that again. It's not bolstering our witnesses' credibility any more than when defense counsel goes through the whole spine or I go through the whole spine. Is that bolstering the lawyer's credibility? No. It's simple definitions of anatomy that are recognized in the medical field.
Well,
They're not
is the
giving-
jury still free to accept or reject what the witness has to say?
I guess a juror could refuse to accept that a vertebrae is a vertebrae.
Well, even beyond that, I mean, just because the witness says this is a vertebrae, does that mean that the remainder of their testimony is automatically more credible?
I would think not. I mean, because if they said this is a vertebrae and it wasn't, it was a disc, objection, Your Honor, they're misrepresenting the anatomy of the spine. Can we approach? And we approach, and then they say, this is why we have to go back through it. They don't disagree that whether it's Dr. Wilkie and an occasional Dr. Bloomfield, that they are representing true, recognized anatomy. It's just like when we put up the dermatome map. They don't object to the dermatome map. It's been recognized since the mid-1800s. And because our expert talks about the dermatome map first, they don't say, well, don't preclude us from going through the entire dermatome map. They don't even do it. And that's the point. They're looking for something to grasp onto to try to get you to reverse on 11 issues in this trial. And I can tell you, 2 weeks ago, on a single case, I got a $1.5 million verdict. There is all of the things that you have ruled out of evidence, we don't use, and the verdicts remain the same.
Why are we continuing to see Dr. Tayyip's testimony being used after
Because this
it's been
case is from
stricken?
3 years ago.
All right.
This was before you ever ruled. There probably wasn't even a case in the appellate court yet, because Judge Schweikert and Judge Reese got so far behind after 125 trials that final appealable orders sometimes took 2 years to get on with post-trial motions and whether the verdict had been entered so that the time clock started running for post-trial motions. We had sometimes that an entry didn't go on confirming the verdict to start the time clock for a year or longer. So whenever these, what you would think are old issues come up, they're not old in the sense of the timeline of the trial versus when the appeal came. This is an older case. And tomorrow I'm in federal court on a case that was tried eons ago, and we're still talking about prejudgment interest. These move, and I don't know why, but they move at a particularly slow speed, even for a snail. And so, unfortunately, we keep revisiting issues that you have already clearly decided one way or another. And oftentimes, they're trying to relate Dr. Tayyip's testimony as if he's wholly and completely uninvolved. He's an employee of CAST. In many times, his own records for the treatment of that patient have been admitted into evidence because he is the spine interventionalist. He does all of the injections and things of that nature.
Is there any evidence in this record that the jury relied on Dr. Tayyip's testimony in reaching its verdict?
No, because if you look at their description of why they made their decision, they are pretty much weighing the live experts against each other. Was it a medically indicated or medically necessary surgery? Now, I do want to bring up one thing that I think is very important, and they've dragged it from the court transcript to the Court of Appeals. They try to claim that these are elective surgeries, and they are if you go by the definition of elective surgery, but they go as far as attempting in closing argument to say it's like plastic surgery. You don't have to have your eyes fixed. No, that's not the case. You have a medical condition that you can elect to treat now or not treat, and you may need treatment later or you may not. That's a completely different issue.
Well, so you're saying these are necessary surgeries?
They misrepresent what an elective surgery is. The question is it medically necessary or medically indicated? Yes, you can have a medically necessary surgery that is not emergent and that you don't have to have now. But if they did it now, under the right set of facts and circumstances, that wouldn't necessarily be malpractice. But the problem here is the underlying facts Dr. Durrani got them to agree to the surgery relate to him scaring them into this by saying things like, you know, I'm the only one that can fix you, you're going to be paralyzed. In other cases, when it's cervical, your head could come off if you're in an accident. And he creates this fear where they feel like they don't have any choice. And that's different than what you're talking about, whether it's medically necessary at that time or a later time. It's being represented differently than what it actually is. And the radiology and imaging studies are being stretched to further frighten the patients. And that's what the jury ends up relying on. What did Dr. Purcell say versus Dr. Saney?
Can you address a couple of the damages claims? So there's one about the punitive damages cap.
Well, I agree that if the judge put on an order that exceeded $350,000, for instance, then it's got to be remanded to just get those numbers correct. I don't have any issue with numbers issues as the law has evolved during these trials. I don't believe that the revised code section was directly applicable at the time, nor was it even raised by the defense when the verdicts went on and then were reduced by the trial court before we came here.
So if there's a math error, you agree it should be fixed?
Yes, if there's math errors or damage numbers that don't agree with the statutory rights of the plaintiffs and defendants, those have to be fixed. I don't have any issue with that.
And the same with the set-off. So on Friday, we released a new precedent about set-off, and would you agree that if there's a set-off issue?
I would agree that if that is something that can be applied retroactively, given how old these cases are, well, then that would have to be addressed. But if you find that it's not something that's retroactive because these cases were tried way back when and not 2 weeks ago or a month or 2 months ago, then that may be a different issue, and I'll leave that to you because I did not look at the retroactive applicability to the situation.
Well, I mean, this case is pending, so it wouldn't technically be
Yeah,
retroactive.
If it
right?
is, the punitive damages are not ultimately covered by any insurance company. And interestingly, if we go back in time to the first case I tried where the final appealable entry was on a fraud claim only with punitive damages, the lawyers paid by Medical Protective didn't appeal. So they care about punitive damages when it's convenient to care because it can be applied to this case to make some argument it ought to be reduced. Okay, well then reduce it. I'm not going to collect it anyway. And in this case, and you've already ruled, that it isn't odd to have identical punitive damages on 2 cases because that's not about compensation. That's about punishment and deterrence. And so that argument's out the window as well. And if we go, the fact that Bloomfield said in these cases, orthopedic spine surgeons and neurosurgeons refer to the surgical process applied to a patient as a case, okay? Oh, I had 4 cases this morning, meaning 4 surgeries. There's no differentiation as to whether he was talking about other surgeries Dr. Durrani performed in a litigation sense or other surgeries that he may have researched to come to his final conclusions or problems. They didn't want to touch it. It got left alone. They even didn't want a limiting instruction, as I remember, that was to be disregarded. So these things come up from time to time because there are so many cases, and these experts on both sides repeat a lot of testimony, and they're there a lot, and they slip up. I don't believe that it was an intentional attempt to poison the well, because I know what the verdicts are, whether somebody tries to poison a well, if that's what they're trying to do or not. The jury is a lot smarter than the appellant gives them credit for. They have notebooks, separate notebooks with dividers to take notes on each case and keep matters separate. The judge went from 1 notebook to 2 because he talks to the jury afterwards. He said, did you have any trouble discerning between the 2 cases? And the universal answer is no.
Is that on the record?
Is that on the record?
Yeah,
No,
can we read that as part of the transcript?
I don't think it's on the transcript because I think it's what occurs case after case.
But my point is, we are only allowed to look at what happened in the record in these cases.
I understand, and I think you'll find many of the comments made in their brief not in the record as well.
I mean, that's fair, but
Yeah.
I mean,
No, I
what you're
understand.
representing right now is not something that is in the record.
No, I do not believe it's in the record.
Thank you.
I think he the record's turned off at that point because the jury has reached their verdict and they've been discharged. And then he says, can I ask you a couple questions? So I think it may not be in the record. But I will tell you, I am not misrepresenting to the court anything that occurred in that courtroom.
And counsel, you're out of time if you'd like to wrap up.
Well, I've addressed the things that were brought up in this oral argument. I just don't think any of the issues are new to the court, and I leave it to you to decide if you find error, whether it was harmless or not, because you're making your own view of the evidence almost as if you're a juror, so it's hard for me to tell you what you ought to do. But I think that the case, other than the numbers related to a few of the damages, which can be solved with a remand for that purpose, this verdict should stand. Thank you.
Thank you.
Judge Bach, I think you began in the right place, which is asking, where is this in the record? And I think that's true of almost everything that you heard from opposing counsel. So he begins with this long description of what happened at trial, which you can find on pages 709 through 747 of the trial transcript. Plaintiff's counsel's description of what Judge Reese said, or his reasoning for limiting the spinal anatomy demonstration, what plaintiff's counsel described to you is not to be found in those pages of the record. You will not find Judge Reese saying, I'm trying to prevent the cumulative presentation of evidence. You will not even find that it's just a straightforward demonstration of spinal anatomy. As I pointed out in my opening argument, if you look at page 723 through 725, you see Judge Reese ask Dr. Wilkie, before you sit down, will you explain the spine slippage condition? Dr. Wilkie then immediately turns to explaining why Mr. Myers didn't have it. That's not a straightforward demonstration. That is the expert testifying on the ultimate question in the case.
Then was there a cross-examination on spine slippage, separate and apart from the demonstration aspect of it?
Your Honor, so we do get questioning and we do get expert testimony on spine slippage, and again, this is a point that does get contested at trial. The problem here is that you have a thumb on the scale on the credibility side towards plaintiff's experts that defendant's experts don't get an opportunity to match. What you have is an expert being placed in front of the jury and the jury being
So
told.
should the
this
trial
person-
court not have asked a question of the expert? Is that
No.
your position?
No, certainly the trial court should not have inserted himself in the direct examination of the expert. I mean, if plaintiffs want the expert to explain.
What rule compels that result? Or what case law?
Your Honor, I don't have case law for you in front of me. But again, what I'm trying to emphasize is that the problem the trial court creates here by limiting us to a one-sided, one expert presentation of the anatomy is not, the more minute question of did the expert get it right or get it wrong. It is that what you have communicated to the jury is that this expert can tell you everything you need to know. The defense experts do not get an opportunity to demonstrate that competence or to make that case to the jury. You have a thumb on the scale on credibility. This is not like explaining the process of board certification, which is not at all the ultimate issue in this case.
Well, why not? Because, doesn't board certification imply competence? When someone is explaining, I've been through this step, I've made this application, this body has licensed me, doesn't that imply competence?
Your Honor.
And then wouldn't depriving other experts under your theory of that opportunity to explain that they too had gone through this extensive process and received these credentials, doesn't that deprive them of the opportunity to appear credible?
It does, Your Honor, but that's not what I mean by board certification isn't the ultimate question. The ultimate question in this case is Dr. Durrani's evaluation of the spine. Did he get it right or did he get it wrong? Well, I point out in each of the joint trial appeals, this court has said Dr. Durrani's impressions of the spine are the question that justify consolidation in the first place. So what you have is an expert being held up as the more credible one, as the guy who can tell you what you need to know on the question of how do we evaluate, look at, examine, explain the spine. That's the ultimate question. Board certification is, I mean, tertiary at best. It's compared to, like, what did we come in here to do? Well, to decide, did this doctor get it right with the spine or not? We actually don't really care whether he was board certified. That's not the question that the jury is being called upon to decide. They're being called upon to decide who is right about the spine. And what you have is a trial judge putting a thumb on the scale, holding one expert up as, this is the person who's going to tell you what's right and what's wrong about the spine.
So
Go ahead.
from your perspective, that's the most important issue for reversal of the entire trial, is that this 5 or 10 page explanation of the spine was so favoring the plaintiffs that the entire however many week proceeding should be reversed?
I certainly think it is by itself sufficient grounds. I think it's important to read that in sort of in concert with what you have with Dr. Tayeb. To one of the court's questions about that, you're not going to find in the jury interrogatory evidence that they relied on any particular evidence. There's no point in the jury interrogatory where the jury says, we found Dr. Wilkie more credible and based our decision on that. All you have is the jury telling you what we think happened with no real description from the jury about where they get that from. We think that the jury instruction was a serious problem in this case. It will not surprise you to learn, I also think that the trial consolidation was a serious problem in this case, but I thought perhaps I would not retread that grounded argument. But I would encourage the court to look at the closing argument description of the adverse inference jury instruction.
Well, counsel, you're out of time.
Right.
If you'd like to wrap up.
Your Honor, I think you have this combination of experts who are misleading the jury with hearsay, and you see it show up in the jury's fraud finding and the depth of their punitive damage verdict. And then you have the court putting a thumb on the scale in favor of the credibility of plaintiff's experts in a case where, you heard it from plaintiff's counsel himself, the credibility of the experts is the critical, liability, non-liability finding. And so for these reasons, Your Honor, we ask you, and for the reasons stated in our brief, we ask you to reverse and remand for a new trial.
Thank you. Thank you both for your advocacy this morning. We'll take the matter under submission and issue a timely decision. Enjoy the rest of your day.